Now you see this is saying DUI science in quotation marks because you'll learn by the end of this section that the science is really up in the air on what you can do and what the exercises actually mean to a jury and to just common sense people. So let's get into it. We're going to start off by talking about field sobriety exercises, and they are called exercises for a reason. A lot of times the public opinion gets it wrong and they call it tests, but they actually can't call them tests. There's actually case law that says there's no such thing as a pass or fail when it comes to field sobriety exercises. All that an officer can talk about is how they interpret the information that they get from witnessing a person doing the field sobriety exercise. So they get to talk about how they performed it, how they went through the motions of the step, how they interpreted the instructions that they were given. So basically a physical and a mental test to them to how a field sobriety exercise does. The key thing to remember about field sobriety exercises is that it is done to establish probable cause. Because after that, if they determine that there's enough factors from those exercises, that's when the arrest, in that timeline that has been talked about before, that's when the arrest occurs. And then they do follow-up stuff with the science and the other technology, which we'll get into, to then confirm that probable cause reason for the arrest. Because they can't actually just arrest because someone has the odor of alcohol, they have bloodshot eyes, and this, that, and the other thing. Because as you know, and as is described in cross-examinations of officers on everything under the sun, you can have bloodshot eyes for a lot of reasons, not just because of alcohol. You can have slurred speech for a lot of reasons, not just because of alcohol. So there's a lot of different steps and technical steps that an arresting officer or a DUI officer has to conclude before they make that arrest. And that's what the field sobriety exercises are designed to do. Now, the basic premise for them is that they are designed to be sort of divided attention. They're supposed to test the extremes of a person's ability to do something and to comprehend what's going on. And they're designed to sort of measure what are considered normal faculties under the statutes. The problem with that is consider yourself, if you have to take a pop quiz in the middle of the road, unexpectedly, your performance is probably not going to be that good. Now, consider the fact that you're also doing activities that you're not commonly doing. They're abnormal. They're irregular. The heel to toe test, one of the field sobriety exercises that's considered scientific, they make you walk heel to toe within a certain number of steps, then do a very short step turnaround, and then walk another set of heel to toe steps. The average person doesn't walk that way. That they're not used to doing that type of movement with their legs, which then can cause issues with their balance. That can cause issues with how they interpret and what they're supposed to do because they're concentrating on those steps, and they might miss one of the cues, which is to do a number of steps. And that's probably one of the biggest issue that pops up when you're doing that type of test is the number of steps that are being done. And that really is something that is crucial. I know in the last section they're talking about how to attack those sort of structured and foundations of a DUI investigation, and that's one of them. Is sort of looking at how a person normally can do that. How can a person normally do these type of activities? Now, one of the things you probably will never see in your career as a criminal defense attorney or a DUI attorney is a prosecutor or the law enforcement officer actually demonstrating these exercises during a trial. And that there's a very good reason for that. And I can use one personal example where I actually saw a prosecutor somewhere in the state of Florida attempt to do the field sobriety exercises. They attempted to do the heel to toe. Now, of course, they were wearing a type of shoe that's not designed to help them balance. Dress shoes are notoriously bad. They don't have proper cushioning or type of stabilization things like a cross trainer does to help a person balance. And this individual, this prosecutor, failed the heel to toe, and it was in front of a jury. And they then muttered under their breath as they walked away after the failure, saying, "Well, I'm just trying to demonstrate how a person would fail this exam." So you see, a lot of times you won't see someone operate or try to do that because there is a percentage of these types of tests where a person will not perform adequately, and it doesn't mean that they're intoxicated. So along that whole idea of the totality of the circumstances, a lot of things can be nitpicked and attacked indirectly or directly from each individual exercise that a person can do. So it's really a lot of common sense questioning that you do in terms of, does a person, when you're asking a cross-examination on a DUI officer, does a person normally walk in a heel to toe manner? Obviously, the answer is no. Does a person normally turn with a series of small steps by keeping their foot left planted on the ground? Again, that's something that is difficult, and a lot of times is one of those devil is in the detail facts that an individual that is, being asked on the spot to perform these exercises, they may not remember the specific detail of what they're instructed to do. Because again, they're doing it on the side of a road, like this photos in the presentation indicates. They are, walking in a straight line with heel to toe, and it's sort of not the normal way. And you may just unconsciously want to keep your hands above to help maintain the balance, even though you're given an instruction that says don't do that. So there's a lot of different things of attacking on those type of field sobriety exercises. Now, normal faculties is sort of defined to include, but not limited to, the ability to see, hear, walk, talk, judge distances, drive an automobile, make judgments, act in emergencies, and in general to normally perform the many mental and physical acts of our daily lives. It's a wide-ranging definition that allows for a lot of different interpretations based on where you're located, what the tests are performed, conditions of those tests, and sort of the different types of things. One of the things that we'll go through, and you'll see that a lot of times there is no test for judging distances. There is no test about their making judgment calls or answering questions. There is no a test to determine how they would act in emergencies. And sort of the generality that is normally perform the many mental and physical acts of our daily lives. There's one of your attacks right there. Normally perform the many mental and physical acts of our daily lives. Remember, the field sobriety exercises are not normal. No one in their daily life is walking heel to toe. No one is touching their nose point to point with their fingers. No one is being asked to recite the alphabet in reverse. No one's asked to follow a pen light in their normal activities. So there's a lot of different structural attacks to the field sobriety exercises that can be done in a courtroom setting. The biggest thing is to know that it's not a pass or fail. There is that definitive case law on this point that says that an officer can't say that they failed the field sobriety exercise, and that is something that is a structural position that as a defense attorney you can utilize in your defense of your clients, because a jury is going to want to have finality in that type of opinion. And if they can't get it from the quote unquote law enforcement officer, that's basically the DUI expert that the state is presenting, that gives you the ability to argue and defend your client regarding how those field sobriety exercises were conducted and also how they proceeded in their investigation. One of the biggest things that is also sort of an issue is if you've ever walked on a road in the state of Florida, or even if it's a country road, a highway, a street road within a city or county within their limits, is those roads are definitely, for the most part, not flat. There's always an issue in terms of sloping because of drainage issues. So there's a natural slope that a person usually has to walk on, and an officer is just looking through their ability with their own eyes rather than trying to see if there is a graded slope on a road, on a sidewalk, or anything along those lines that would prevent someone from adequately performing it. Remember, some of these exercises are claimed to be scientific, but they're not performed in a scientific laboratory where they can control all the conditions, the weather, the type of shoes or the type of shoes that an individual is wearing, or that it's free and clear debris. Wind blows things onto a road. You may step on a rock that affects your balance, or a pebble that wasn't seen because it's dimly lit, because it's at midnight and the street light is not going to give you the complete picture of what they're walking on when they're performing those exercises. The exercises are also considered non-testimonial. So a lot of times you may have clients say, well, I wasn't read Miranda before they started their DUI investigation. That is something that you always have to sort of preface with them. We're saying that law enforcement does not need to read our Miranda at that point when the field sobriety exercises are being given. Because remember, they're designed to see if there's probable cause for the arrest. Until that there's probable cause for that arrest, there's no need for law enforcement to read Miranda because the exercises are not sort of testimonial in claiming something that your client has done or said. Now, when we're talking about field sobriety exercises, there's a standard set of 5 that law enforcement uses. There are other ones that are also sort of on the fringe, but there are 5 general ones that are used by law enforcement in the state of Florida. 3 of them have been scientifically verified, and that basically just means that the Administration for Highway Traffic and Safety have done studies to talk about how many of these tests confirm that someone was drunk after the fact when they do blood testing or breath testing or urine testing to confirm that they were under the influence through their testing mechanisms for that. Now, 3 that are scientific are the horizontal gaze nystagmus, walk and turn, and the one leg stand. The finger to nose and the Romberg balance, those are not considered scientific because there hasn't been enough testing done to confirm whether they're valid or not. Now, some of these require expertise training to do, such as the horizontal gaze nystagmus. Your jurisdiction may require that the officer be designated a DRE or drug recognition expert. What that basically means is that they've gone through specialized training, or what basically called DRE school. DRE school goes through testing how to perform the HGN or horizontal gaze nystagmus test and how to perform it in adequately to prove the specific scientific designations. Because with that test, an individual has to basically show nystagmus, which is basically eye flutters when your eyes move to the side, left or right, that there is sort of not a smooth movement or following of that red light pen that an officer would use. There's a lot of specifics to this. And if you take a look and you can actually look at the material that's is used to train officers on DRE school by doing a search, and you can actually get the actual manual that they use. It shows that they initially will use a piece of paper that's folded. So it sort of gives them that 45-degree angle on both sides. And that's how they will test when they reach that 45-degree angle. Because an officer will basically say that the nystagmus has to be onset before the 45-degree angle. Because the science behind it is, after 45 degrees, our eyes naturally may have some flutter in them that would be associated with every general person, whether they're drunk or not. If it happens before the onset of the 45-degree angle, that is supposed to be an indicator that someone is under the influence of some sort of substance that is affecting their ability or their normal faculties. That is why it's considered one of their scientific tests. But because it is more scientific, quote unquote, than the other tests, a lot of times certain jurisdictions require the DRE school to be completed. And if you're not familiar with DRE school, it's somewhat what I would say is the third level of a DUI officer's training. First one is their general training through the academy or what they do to become an officer or deputy. The second one would be ARIDE, which is sort of the advanced DUI and field sobriety exercises training that an officer can do. And then the third would be the next step is the DRE school, where they learn how to perform that test within the specific distances and how it's supposed to be done. Now, with HDN, there's also vertical HDN, where an officer can further test it going through up and down to see if there's nystagmus as well with the eyes doing that, but is not as important as the horizontal one, which is the basis for the test and why it's considered scientifically valid. With an asterisk, not which we'll get into after we talk about all the other tests that they do, or exercises that they do. The second one is the walk and turn. This is the one where someone walks heel to toe with a certain number of steps. Then they make the small turns with their feet and then walk back. This one is really designed to go over a lot of different instructions that an individual has to pay attention to and follow. And a lot of times there is missed cues because it's a lot of different things that you have to follow and complete with doing that. And there is no sort of instruction or clarification to an individual performing this walk and turn because they say to walk and turn small steps. But to the average person, they may think like, oh, I get to that 9th step and I will just do whatever I need to turn around rather than knowing that they have to follow the instructions to a T. That sometimes is not instructed to them, and they're not told the importance of why they have to do it that specific way. And when you're outside of your comfort zone and you don't know that is something that has to be performed on that examination, you're then facing the problems of getting what's called a did not perform it adequately. And it may not be because you're under the influence. It may not be because you have a physical ailment. It may just be because, simply enough, you didn't understand the importance of doing that exam to the exact specification of that officer. And there isn't enough time for you to comprehend that, to understand that portion, because you're sort of put on again on the spot to perform that field sobriety exercise. The next one that's also scientifically been tested is the one leg stand. Now, this is basically an examination that is very abnormal because there's very few times where you will be required physically to stand on one leg and lift your other leg to an area where it's basically your femur is perpendicular to the road, and you're maintaining a balance with your hands by your side for a set period of time, which is about 30 seconds. The ability of doing that, depending on, certain advances about the road being actually, even so that you can maintain balance, on the fact that you may have never tested your balance for years, even if you are active. You don't know if the balance that you're going to conduct or you're going to do when you're lifting up that one leg is going to be able to maintain that posture for 30 seconds. And that comes down to a lot of factors that don't have anything to do with alcohol, without impairment through drugs or anything along those lines when you're performing them, again, on the spot. Now, the next test, finger to nose. This is a test that hasn't been sort of verified by the Highway Traffic Safety Administration, but is a test that a lot of times officers like to use. Now, the problem with this test, and a lot of times when you look at a body cam video of it being performed, there are officers that like to indicate when the proper test isn't done right. Now, you may think it's a simple test, just fingertip to nose. But depending on how your finger touches the nose, they may say it's a failure. If your finger does not do the tip to the exact tip of your nose, that can be considered a failure. The fact that you're using part of the pad of your finger rather than the tip can be considered a failure. You touching around rather than the exact center of your nose tip, that could be considered a failure. And it's very highly technical. But again, a lot of times a person that's asked to perform this is not going to be cognizant of the fact of how they need to perform it, how specific they need to perform this test. And they're going to think that they're doing well because they are, their fingers are touching the tip of the nose as they're performing it. And then the same thing with the Romberg balancing test. It's, again, another unnatural position for a human being to perform. Now, why is the holistic or the totality of circumstances important to this? Because the statistics that even the Highway Traffic and Safety Administration have performed is that HGN, which is supposed to be the most scientific test, is only accurate on its own around 60 to 70%. They basically had to include that they have to fail that, the walk and turn, and the one leg stand to increase that probability to something that's more certain. And the statistics for that is around, I think, 90%. That may have increased over the years, but it's around that position. So there's still a 10% failure thing here of they may have failed all three of these tests, but there's still a 10% chance that they're not under the influence based on statistics alone. So it's very important to look at the statistics, the structure of how that investigation happens to attack the standard that you would have in a DUI trial, though, beyond a reasonable doubt. Does 90% certainty mean that it's beyond reasonable doubt? That's up for your jury to decide, and that's up for you to argue in the defense of your clients. Now, there's also seated exercises that are available to use, and that's usually with the finger to nose and the Romberg balancing and sort of like the reading the alphabet in reverse that you may see on a DUI video or on a TV show. But those are not considered scientifically viable because they haven't been tested like HGN, walk and turn, and the one leg stand, which are basically standing exercises rather than a seated exercise. So since those can't be performed in a seated one, those are typically not considered scientifically viable for that sort of statistic that the Highway Safety Transit Authority is basically looking at there. Then there's the fingertip to nose type of test. It basically has those standards there of how it looks like it's correct. And it may look like this individual in this photograph here is doing it correctly, but again, it's something that an officer on a body-worn camera may have some sort of sign language or some sort of signal that they would do that they will then use at trial to indicate, okay, he failed this portion, he failed this portion. Because typically that body cam will be at their chest level and won't have the same eyesight that the officer would have, which would be directly perpendicular to the individual performing the test. So a lot of times they will include their own, interpretation of how they performed it on the body cam to use that trial. So it's sort of a method of including some more information that they may try to use on those types of exams or exercises. Again, a lot of times they record field sobriety exercises on dash cam videos. So if your jurisdiction has a DUI task force, almost all of them, all their vehicles will have a dash cam in their car that they will utilize to record the video on top of their body-worn camera, just because it gives a better whole shot of the exam being taken. But like I said, again, the flat, even surface here you can even tell on this dash cam, it does not look flat because there's pools of water on the ground because it was raining. So you don't know what the condition on that roadway is. The dash cam's not telling you if it's slippery or not. The dash cam isn't telling you what else is on the floor. Is there oil on there where the water is? Is there pebbles? The roadway here on this photo gives you a lot of questions that you can question. And like a lot of times you've heard the saying before, a picture is worth 1,000 words. In this situation, there's 1,000 different avenues of attack for your DUI defense that you can bring up with the prosecutor, with the jury, and with the judge in terms of motions that you may try to file or try to act out in your trial and your defense. So the HGN test, a lot of jurisdictions allow police to talk about this, even though they're not a DRE school graduate or they're not a DRE officer, but it sort of limits them to say that they have performed a pen test or a pen-like test for them that follows a pen. And that's about all that they will actually testify to. They won't really talk about the results or how they were able to measure the horizontal gaze and nystagmus because they aren't DUI experts. But they're still allowed to mention that they performed something like that for the purpose of the testimony that they're presenting at the trial. Now, the walk and turn is, again, like I said, an instructional type of test where they're given a lot of different instructions and they're told they need to complete it within a certain amount of time. So they are really put on a stress factor to do the 9 steps forward, turn in a small series of steps, and then 9 steps back. Now, why is it important to attack this whole 9 steps forward, 9 steps back? Is because that's sort of an unnatural number to an individual that's performed these exercises. A lot of times I've seen this, and you will see this through your journey through defending DUIs, is that individuals like to think in round numbers. So 10. Or they misinterpret what the 9th step means because you're doing it heel to toe. And then you also have to do that turning around in small steps. That 10th step that might be counted by an officer might be you thinking that you're beginning the series of small steps rather than it being interpreted the right way or another way of that you've actually done the 9 steps and that 10th step is you starting the series of steps to turn around. So it's a lot of miscomprehension, misunderstanding that can happen to an individual that has nothing to do with the impairment of their daily faculties of completing those types of physical tasks. So it's important to understand that. And then again, with those small series of steps, it's an unnatural way of turning around. No one actually has ever really in their own natural daily activities done sort of turns like that, where they're doing little tiny steps to make that turn. And again, it's not an emphasis that's told in the instructions that you must do it exactly like that. You cannot turn a different way. And that is something important to know when you're presenting that to a jury. The one leg stand is, again, and this sort of demonstrates this photograph here of how sometimes difficult it is, especially with the type of shoes you're wearing. If you're coming off work, you're wearing dress shoes. That's not going to be the best type of shoe to balance, especially if you have to raise your leg 6 inches off the ground and hold it at that sort of perpendicular thing with your foot to maintain that type of lifting of your foot. Because there's nothing for you to show like, oh, am I doing it 6 inches above the ground? Is it below 6 inches above the ground? Based on your point of view as the person who's performing this exercise, there is no way of actually determining if you are successfully doing it because there's no measurement. There's no one giving you feedback. Am I doing this test the right way? And that's sort of the thing that we're going to talk about, that there's no, standard for someone to do this. No one is trained in school to do these exams so that they can, or these exercises, I keep calling it exams, these exercises in a way that allows them to be ready to do them, to test if they are under the influence or not. So it's not a normal faculty at the end of the day. And that's an argument that can be made to a jury. The other problem with this test is a lot of times the failure or the indication of intoxication is because they didn't do it for 30 seconds. And I can tell you, I've seen police reports that say that they performed this within 27 seconds, and to them that showed a sign of intoxication. Now, one of the instructions that they sometimes do with this is tell them to count in 1/1000. Now, someone talking as fast as I do, a 1/1000 is a lot faster than what an officer may believe a 1/1000 would be. That's an approximation. It's not really hard or fast with that rule, that instruction, that it means that you are under the influence because of how you calculate in time the 1/1000th, or getting into a 30-second time threshold to keep your foot raised 6 inches above the ground. The finger to nose test. This is something, again, like I mentioned, has not been approved by the NHTSA. It's another one of those instruction exams where they're supposed to follow directions. Their arms are supposed to be held out and their index fingers pointing out. And then you close your eyes, tilt your head back, and attempt to touch the tip of your nose with the tip of your finger. Now, it is very, very nitpicky on how it actually is performed. Like I said, a lot of times officers on their field, on their body cam, are going to indicate signs of failure or signs of intoxication based on how they perform this test. And they usually have to do it around 6 times. But the biggest thing to always attack, if this is one of the exercises that is given, is the fact that this is not a scientific test, which you can question on, or exercise. Again, apologies for talking about exercises, not tests. And also the fact that it has the ability of being interpreted differently depending on how your finger to nose is touching. Because again, the officer is also at a different angle, may not witness the actual, may think there's a failure of the instruction, but in reality, it may not be, because they, through their point of view and their feel of them touching their nose, are doing it the right way. The Rotberg balance test is another one that's also an instructional one. This is a test where your feet are being held together, your arms by your side, you close your eyes, you tilt your head back, and then you count for 30 seconds. This is another one where you have to basically control time and think to yourself of counting in those 1/1000s, 1/1000, 2/1000, 3/1000. And realistically, the only type of signs of failure for this and this type of exercise is people either counting too fast or too slow, where you're outside of that time frame, or you don't count to 30 seconds, because sometimes they may be slow or they may take longer to do that. And that is, one of the reasons why this is not one of those standard tests that are performed or that are utilized by the National Highway Traffic and Safety Administration on proving that exam is, or that exercise is valid. Another series of questions that you ask is to ask the officer, because they usually go through different trainings, through the basic training in the academy, the ARIDE advanced training, and the DRE school, is that they've performed a lot of these exercises to see how it's supposed to be performed. So they've had a lot of experience on doing those exercises. Now, best way of sort of equating that is consider someone that is learning how to play tennis. They're not going to be able to perform, different types of shots, different types of angles of attack, because they haven't learned it. Now, even though they may be, trained and someone taught them how to do it that day, it doesn't mean that they're going to be able to do it with perfect accuracy every single time. And the same thing is true with field sobriety exercises. So making that analogy to a jury, to a prosecutor, if you're trying to make an argument of how these exercises are not, being performed perfectly like they would want, like an officer would want them to be, or a prosecutor would want them to be, because a lot of times they haven't done it. So it's a great avenue of attack for common sense for a jury to think about that on how they perform it. And how many times they had to perform it, and how much time it took them to master the ability to perform that. At the end of the day, you always ask the question, why didn't they just demonstrate it at the trial? The reason for it is because no matter how many times the officer has practiced it, there is no guarantee that he's going to do it right every single time. And that doesn't mean that they're that officer is under the influence. It just means that there is not a perfect result to these exercises every single time that they're done. And that goes back to that scientific quote from the HCSS Highway Safety Traffic Administration, that it's only a 90% certainty at times all these exercises being found to find that someone's under the influence. There's a lot of times of also then asking what they did perform well within that exercise, because if your jurisdiction has sort of what's called a DUI checklist, you'll have all the different factors that an officer is supposed to consider when they're gauging if someone is under the influence or not. So a lot of times we attack the ones that they check off, but we fail to go over and mention during cross-examination of the things that they did right. Like they did do the number of steps correctly. They did do the many tiny steps going forward. They did walk back the 9 steps, but an officer says, they sort of lost their balance, or they're waving back and forth. So that showed a sign of impairment. You really want, a lot of times, you may have the potential of attacking the number of positives versus the number of negatives. And in that situation, you have the ability of presenting reasonable doubts to a jury that the person wasn't actually intoxicated and not under the influence. So it's a lot of times it's up to the situation and the circumstances of how that individual has never had to perform these types of exercises. Again, think of that pop quiz example. And that's sort of with the example here. You're pulled over quickly after lights and sirens are activated. You're tense. You're giving over your license and registration. Typically, this is a first time a person is has an interaction with law enforcement. So there's an added stress factor there that's affecting their ability to perform these types of exercises because they haven't been told to do it before at all. It's almost like they're performing it at a state of duress from being able to perform adequately or normally as they would if they had time to prepare, if they had time to train, like the officer had time to train on how these exercises are performed. And a lot of times an officer is confused with the average with the types of movement and how much distance someone is holding up their leg. Again, it comes to perspective. Is it someone holding their foot up 6 inches? Well, an officer from that angle from where they're looking at may misinterpret or overestimate or underestimate the position of that, how they're performing that exercise. So you may not be able to fully comprehend how they're doing it. The heel to toe, they may think that they're not walking heel to toe because there's a gap between their foot from what they see in that angle. And that is something that can be, again, overestimated, underestimated. A lot of times that affects the performance, that affects the review that the officer's doing, and affects the judgment call of the officer to think that there's probable cause for the arrest on a DUI. And it's something that can be legally challenged and factually challenged in a court. Then you have basically the different types of medical conditions that can affect the field sobriety exercises. Now, the biggest thing that I see a lot of times in DUIs is a lot of times people are just going to say like, oh, there's nothing bothering me. And then later you find out that they were involved in a car accident. They're getting chiropractic work. They're doing physical therapy. And there's a doctor that's considering doing a spinal fusion on them because of that car accident. But the individual is going to say like, I'm fine. I can do the field sobriety exercise. Again, this is something that is outside of the norm for someone to know what the field sobriety exercises are and how their physical condition can affect their ability to perform it. Because again, they haven't done that. They haven't done these exercises before. They don't know how their ailments, how their physical ability will affect them in performing that exercise. There's no such thing as a cookie cutter. Every single person should be able to do these exercises. Again, why? Because they're abnormal. They're not something that is normally done by an individual on a daily basis. And they're not given the opportunity to train and practice these exercises before they perform them. It's not something that's required to get your driver's license. It's not something that's required to get your learner's permit even. But it's something that is relied upon by law enforcement in their investigations. And you have to know that it's not foolproof. Statistically, it's not even foolproof. And it's something that you should attack on every case for the totality of the circumstances. That leads to sort of the totality here, which is the sort of how it fits into the definition of normal faculties. Some of them, like we talked within the statute, their speech, their ability to walk in balance, their mental faculties, and their abilities to make judgment or act in emergencies. Starting with speech, especially in Florida, we're lucky to live in a melting pot where we have people from all across the world. Not everyone is a native speaker. Not everyone that is even born in the U.S. speaks proper English because there's dialects based on where you live. You may have heard of the Miami accent. If you're in Miami, you may talk completely differently than someone in Orlando or in Jacksonville or in Pensacola. Everyone from these different regions may have a different type of accent because of how they were raised, where they come from, or their culture. And that is something that can be misinterpreted as being slurred speech, especially when you're talking about people who speak, what's called in terms of, a Creole or Pidgin English, if you're coming from a Caribbean country like Jamaica, where there's, English is involved in their daily speaking of how they talk, but because of regional differences in the dialect, it may be incomprehensible to someone who is an officer who, moved down to Florida from the Midwest and doesn't understand that different type of effect on a person's, ability to speak. And that is why it's important to sort of pay attention to those videos, see how the interaction is going, and see if that it's really a person that's under the influence, or if it's something that is difficult for them to understand because of the way they learn to speak English. And there's so many different ways of attacking this and approaching that based on the individual circumstances. The walk and balance ability of an individual through through the statute. We all don't walk the same. There's a lot of talk about people's gait of how their stances are. Me, I'm an individual that's 6'4", so my walk and my stride is way different than someone who's 5'3" or 5'10" even. So there's a lot of differences in how we walk, and it can create awkwardness in terms of how you perform the test. So for someone like me who is 6'4", who has very long legs, in essence, you can call me a human ostrich at a certain point. Doing those small steps on that heel to toe test on the walk and turn can be difficult for someone of a taller height to perform, because there's a lot more mechanical movement that's required for longer legs than there would be for shorter legs. That would have a person be able to better balance themselves than someone who is way taller and has to utilize a lot of different body mechanics to maintain their balance and standing up straight. Then there's the mental faculties. There's a lot of different way people learn and listen and understand rules and instructions. You may know someone that's the smartest person in the world, but they're not a verbal learner. They're a visual learner. So someone that is telling you instructions of how to perform a test may not comprehend it as well as if they were given a card that said, perform this exercise based on these instructions. And a lot of times that is a key indicator for individuals that law enforcement says they couldn't follow these simple instructions. Well, it may not be simple to someone that is a visual learner rather than an auditory learner. Even though an officer may perform that exercise, they're not given enough time to absorb that information and know whether that exercise is being done correctly or not. Now, sometimes they will give the verbal instruction and the visual instruction and do it in a way that is able to be, interpreted by the individual that's performing the exercises. At that point, then you're sort of running out of arguments that you can make, and law enforcement is doing the right thing with how they are going to perform those field sobriety exercises. And then the acting emergency and making judgments. Some people, like I said, are nervous, and when they're nervous, they are not performers. They cannot perform. They sort of get into a situation that they're outside of their comfort zone, and anyone that is outside of their comfort zone is not going to be able to willingly perform exactly as someone is instructing them to do. No matter if an individual is compliant or not compliant for whatever reason, whether it be alcohol, drugs, or just they are, sort of a, what people may call a free thinker. Like, I'm not going to do what someone's telling me to do because I don't see a purpose in doing it because I'm not drunk. Right? Now, to an individual that is not drunk, that may sound like it makes sense. But to an officer, to a potential jury, that may come across like, oh, they're trying to hide something. And that may not be the case. And it's something, again, that's up to interpretation. And it really comes down to, a viable attack for an individual to do, and then breaking down those instructions, attacking them one by one with how they performed it or how they dealt with it or conceived it during that stressful situation. Here's an example of just how you see how many different instructions you have on that sort of that heel to toe or walk and turn type of test. And there's a lot of different rules and instructions that you're given. Really just looking at here, this basic one is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17 different instructions that an individual is supposed to follow for a field sobriety exercise that is meant to determine if they are under the influence or not. Now, they are told these instructions without being given a reason why this is important to follow that rule, so that when they don't strictly comply with that rule, that gives an indication that they may be under the influence. So again, you have sort of the misunderstanding, miscommunication that can happen through just giving these basic instructions for which just one of the field sobriety exercises that the individual may not comply with because they don't understand that it's important for the heel to touch the toe, that their arms need to be relaxed at their side. Think about that. Again, stressful situations. Someone might be tense when they're performing these exercises and not be able to perform it adequately because of the situation that they're in. So it's something to always consider, that there is not a cookie cutter response for someone to do this type of field sobriety exercise, which just shows how complex it is. You'll notice here, the instruction in this situation is you'll make a U-turn. It's not really talking about the specifics of how you're supposed to do those turns within that test. And that's another thing to always be mindful of it. There's a good saying that I like to rely on, and there's two versions of it. God is in the details and the devil is in the details. And depending on what details are followed or not, is, which phrase you should be utilizing or which phrase you follow as a person. And a lot of times, in a lot of different situations, the details are important because they lead to showing in a defense of the DUI whether there is, probable or there is proof beyond a reasonable doubt. And a lot of times it can be a game of inches in a trial to making that determination and making a jury find that there isn't that the state hasn't met their burden of proof beyond a reasonable doubt. Let's face it, usually when a case goes to trial, it's one of two main reasons. Number one, client's belligerent and they want a trial. Number two, the facts are 50-50 in essence, and there's a legal argument or a factual argument you can make to defend on a DUI case. Now, for DUI cases with good clients that do pretty well on field sobriety exercises, when you're thinking about jury selection for those types of cases, this goes against the norm. But you really want people that are from a sort of leadership role. So a teacher, coach, managers, people that assign people tasks and sort of have benchmarks for them to complete and adequately do what they're supposed to do. Why do you want these type of people? Even though they might be considered judgmental type of individuals because they judge people on how they perform, is because it's rare for these types of people, managers, coaches, teachers, to have someone that is perfect on the first go. That is a reason why students go to school throughout a semester or throughout a school year. They're not just being told something and they automatically remember it. That's sort of a situation where they're basically the Mike Ross. I think Manny mentioned Suits. That's a great example. That's a completely abnormal person that can learn and regurgitate or go back and do the exact same thing after just witnessing it once. So a lot of times that is something to consider, and those type of people know it. Coaches know it as well. No one is perfect besides, the story of Michael Jordan, how he never really, trained or practiced basketball. He just was a natural talent. Those are the exceptions to the rule. A lot of times it's training that gets people to be able to perform to the level that they need to. So that is those are reasons why coaches and managers and teachers are the best to basically explain that, because you can tell them that if that were not true, there would be no need for teachers. Everyone can just go on and read and learn and maintain that knowledge without a teacher trying to help them understand that and clarify that in their mind. There would be no need for coaches to train athletes on anything because they would be able to just perform perfectly on the field of their sport or any physical activity that they're doing. And managers wouldn't be needed either because companies would have their employees be able to read the rules and follow without any issues and perform to an excellent standard every single time. Those types of people get it. They understand that sometimes you need to be properly trained and do those types of activities. And if that's going to be your method of attack on a DUI case and your defense on it, then those are the types of people that you want because it's only going to be useful for that type of theme, that type of theory that you present. If it's a battle between the field sobriety exercises for that DUI trial. Of course, there's always the other area of attack that's going to be brought up, but we're going to get into that in about a minute or so. And that is right now the dreaded Breathalyzer 8000. The state of Florida is one that has that deemed that the Breathalyzer 8000 is their basically gold standard when it comes to breath testing for DUI cases. Now that's going to be changing soon because there's this new device called the Breathalyzer 9000 that's a little bit more updated in the technology. And I believe the state of Florida is going to be transitioning to that. They said it was supposed to be happening in 2025. With the way government works and buying a lot of new machines, that's probably going to be a longer process. But you need to be on the lookout for the Breathalyzer 9000. Some of the attacks that people at the 8000 will be sort of diminished, allegedly, based on the science and the new technology that they're including in the Breathalyzer 9000. So let's break down what the Breathalyzer 8000 is. It is a device that was first introduced by a private company in 2001. If you're shocked that a piece of technology from 2001 is still being used at the gold standard to determine if someone is under the influence of alcohol, then you're not wrong to be confused and shocked by that. To put it in essence, or something that you can even mention at trial, the Breathalyzer 8000 came out the same time that the Motorola Razr flip phone came out, or even more so, more shocking. If you remember those Nokia brick phones that had the snake that those are almost indestructible. That's the same time that the Breathalyzer 8000 came. Now imagine that you still utilize that phone, that Razr or that Nokia, probably it doesn't make sense. And it's a wonderful argument to make about how sort of the technology is older than it needs to be. To put it in context in terms of the timeline of the Intoxilizers in their different series, is that it was there was a 10-year period, I believe, from the Intoxilyzer 5000 to the Intoxilyzer 8000. Right, so that's a 10-year span from one version of the machine to another. Now there may be 6,000, 7,000 in there, but you're seeing sort of like the range of when that device became viable, when the company came out with a new one. Now with the Intoxilyzer 8000, we are about 25 years from the introduction of that machine before the Intoxilyzer 9000 comes into full use in the state of Florida. Now, there's a lot of things that can be wrong with technology, and we could compare how technology was 25 years ago to how technology is now. We're talking about a time frame when there wasn't Wi-Fi. If you can imagine that, or if your jury can imagine that, and if they've always grown up with Wi-Fi, or they don't remember a time before Wi-Fi existed, that is a key factor. Depending on how young your jury is, they may have been born after the Intoxilyzer 8000 ever came onto the market. That is another thing that just shows how sort of antiquated the technology is. And it sort of relies on this test that the Intoxilyzer 8000 uses is based on one scientific method of analysis, which is an infrared radiation laser, which goes through where the area of air that a person blows into the machine goes to test a certain aspect of their breath. And that test isn't actually to determine their blood alcohol content, but something indirect to blood alcohol content, which we'll go into. So to break down on some of the key areas of unreliability to the Breathalyzer 8000 and its 25-year-old technology, is that there are a lot of different issues to consider. So the scientific viability for this test comes to the scientific thing that they tested within a closed environment, which requires it to be at a certain type of temperature, which is around 34 degrees Celsius or around the 80s to 70s degrees Fahrenheit, to make sure that the breath is adequate or accurate when they're doing testing. Now, why is that to be in that range? Because when tested, the breath of an individual, if there is in a hotter environment, may actually amplify the actual level of blood in their, the actual level of alcohol in their blood. And the same thing, if it's lower, it may also underestimate as well. So you have a test that is sort of getting an estimation based on environmental circumstances and the weather or the temperature of their breath, that they have a fever or they're suffering from a medical condition, may overestimate that blood alcohol content within their breath. There's also a margin of error that the machines have to talk about. The time of when the test occurred. A lot of times you'll see there's a 20-minute observation period, but you don't know how long it took the officer to bring someone to that observation period. Some officers perform the field sobriety observation, the blood alcohol observation on the scene, and they have a mobile Intoxilyzer 8000, which has its own issues in and of itself, of performing that observation period there. But they may not follow the exact terms that they're supposed to do, and that creates different issues. There's the 0.02 agreements. What this basically means is when you're doing a Breathalyzer 8000, an individual has to be tested at least twice. And when I say at least twice, is because the machine, if there is a difference between the blood alcohol level that's performed within about 5 minutes or so of over 0.02, there has to be a third test to confirm the validity of those other two tests. Now, this is sort of crucial. So if you've ever looked at a blood alcohol test report, they're basically all standardized. They all look the same. On one column, which will be a short little column within the middle of the page, will be what the time marker is talking about, whether it's like sort of a test, 0 air blow, test to see if the machine can read at 0, and then a sort of test to see whether it falls within the margin of error for the testing parameters for that. And then there is the actual breath test that occurred. Now, after that, on the other column, which is another one that has a series of numbers going down that column, those are basically the results of those tests and the actual breath test that's being done by the individual. Now, over to the next part of that, there should be any error codes, if there are any error codes for that particular test. Now, sometimes when there is that variance that's above 0.02, there might be an error report saying too little breath or did not fill volume or something along those lines, or a mechanical version or failure for that test. A lot of times you'll see this with an individual who has reduced lung capacity. They can't fill up the volume that they need to in the Intoxilyzer 8000. But if there is a necessity or a third test, that creates another issue there, which means that the machine itself is requesting a third test because there is a wide variance, there's a difference in that blood alcohol from their breath. And that is something to consider. How can someone's blood alcohol change drastically that it drops beyond a 0.02? Remember, legal standard is 0.08. So when we're playing this game of inches, a 0.02 or greater difference is monumental, because you can go from something that is below the 0.08 requirement for someone to prove that there's a presumption that they're intoxicated. So it's a 0.07 and their second test is a 0.09. Well, then that third test, what's it really going to prove? What's going to show? That there's now a third different number, because that most likely that number is going to be something that's different than those other two tests. So again, you have something here to attack on how the machine is operating. And then there's the attack of the source code. Now, what this is really talking about is more about the history of that machine, how it operates, how it tests, and how it's operated in the past. There are horror stories about that, which we'll get into talking about that. So I'll say that for that slide. So the estimated standard for a field sobriety exercise or a breathalyzer test, I'm sorry with my words today, is 34 degrees Celsius, which is 93.2 degrees Fahrenheit. That's sort of around the area where a human body temperature should be. So if they are suffering from a fever, that might affect that. It may affect their ability to blow the full amount that's required within that. So like I said, lower temperatures will decrease the blood alcohol content. And a study in 1995 showed that over 700 subjects, they found that temperatures ranging between 33 degrees Celsius and 36.7 degrees Celsius. So they recommended that there should be an estimated temperature in the 35 degrees Celsius instead of 34 degrees. But you see here, the temperature has an effect on what the blood alcohol content is within an individual, the BAC. So if you understand that science, you can attack that science, because the breath tech operator who's going to testify to that is something that should know, because they're going to be labeled as an expert in DUI investigations and testing with that breathalyzer test. And they're talking about all the on direct examination of the prosecutors, and talk about how many times they perform that field sobriety, that breathalyzer on an individual, how they know that machine, how that department may have had that machine for years, and there will be records of all those tests for them to do. So a lot of times, if we're not following, if they're following that 30 degrees Celsius estimate that they're supposed to, and instead of following what current studies are showing, then almost 100% of the time there's going to be an overestimation of the blood alcohol content of an individual. Then there is the partition ratio. Now, remember I said that the Breathalyzer 8000 indirectly tests the blood alcohol content, or BAC. And that is because that the actual test that the Intoxilyzer does goes into what the blood alcohol concentration is, or RAC, which is then utilized with a mathematical equation of the 2100 to 1 ratio. What that basically is the variation between someone's blood alcohol and their breath alcohol. Now, breath alcohol is basically the alcohol that would be on someone's breath. So you may have heard of standards where people are using mouthwash, and that drastically changes the result of the Intoxilyzer 8000. And that is because it's going outside of this ratio of 2100 to 1, because their breath alcohol is excessively higher because they use something like mouthwash that may have alcohol in it. So the fixed ratio is utilized to sort of come up with a blood alcohol content for an individual. Now, there's a problem with that. And that is because it assumes that everything is operating again under that 34 degrees Celsius standard. Now, that's scientific, but that's not real world and how people operate and how their body operates. Remember, there is no such thing as a cookie cutter human being. Every person, and it's almost common sense of bringing that up of people's knowledge. People get drunk, quote unquote, at different rates. Based on their size, based on what they've eaten, based on how their metabolism works and how they break down alcohol, based on their medical condition like diabetes or other sort of metabolism disorders that an individual has that affects the absorption and the calculation for this ratio. So it really varies, rather than it being a standard 2100 to 1 from studies. It goes from about 900 to 1 to about 3400 to 1. Now, that's a huge difference that we're talking about, over 2,000 different numbers. And to sort of understand that is sort of the number that the breathalyzer gets is multiplied by the 2100 to come up with the blood alcohol content, the BAC. Remember, the machine itself calculates through that infrared laser infrared radiation to come up with the BRAC, with a blood alcohol concentration, because that's the volume of air. The laser then makes a quantified number, and the number is then multiplied by the partition ratio to come up with the blood alcohol content. But when you're dealing with something where you're dealing with technology that's old and a cookie cutter number to multiply to come up with the blood alcohol content, how accurate is that blood alcohol content for a jury to consider if it meets the burden of beyond a reasonable doubt to determine if someone's under the influence and affecting their normal faculties? See, it's sort of the totality of the circumstances keeps building up here in terms of how that machine operates. Now, the problem, a lot of attorneys fail to recognize that they see that this is a machine, that it is, tried and true, tested. It's been utilized for 25 years, and they're, it's rare to attack it in that situation in a trial. But realistically, if you take a look at all the aspects of how that machine operates, there's a lot of variables that are not concrete to making a determination of what the blood alcohol level is in an individual. So again, there is the different types of ranges, and we talked about the margin of error, and that comes along with the 0.02 agreements, but also comes along with the testing of the sort of the machine before they operate to make sure that the machine is operating correctly. Now, the breathalyzer machine has its accepted range for results. So a lot of times, if for a 0.5 test, meaning that the test is machine is given a sample that has a standard of a 0.5 blood alcohol content, it's fine if the machine gives a result that's in between 0.045 and 0.055. Same thing with a 0.0 test and a 0.2 test. There's this range that the machine is considered that it's a passing test within that acceptable range of the test. Now, why is that important? Well, because on a breath, when it's actually testing the breath of a suspect for a DUI, there is no accepted range based on what that blood alcohol content is, because it's an indeterminate value, right? So if you're talking about a scientific test, you don't know what the range of acceptability is to that. So if a test, machine comes back with a test of 0.05, there may be a higher chance that there's an overestimate of a blood alcohol content. But that's not necessarily true. It may be that the fact that the machine is not accurate enough to do the test. The lasers could be failing. The instruments that are reading the amount based on the radiation test of the infrared light that's being passed through the container that has the breath may be failing at that point in time because they're overused. So the machine is reaching the end of its life cycle. These machines aren't perfect. They don't last forever. So a lot of times that acceptable range is not imparted upon the actual test that's conducted. And that sort of gives you the fact that it's not a concrete result of what their blood alcohol is based on just their test. So there's no real margin of error for that breath test that's being done by the Intoxilyzer 8000. Now, the 0.02 agreement we talked about a little bit, that's sort of the scale analogy. And the really scary example is someone has their first test and it comes back a 0.079, and then a second test that comes out 0.098. Both are valid samples, and they're both within that 0.02 agreement that the machine does not require a third test. But the problem is now the blood alcohol is below the legal limit on the first test, and then above it on the second test. And then there's a potential that an officer is going to do what's called a retrograde extrapolation, where they try to come up with a bell curve to show when that test occurred or not. Now, some jurisdictions with their toxicology experts that they have, dismiss the science of doing one of those retrograde extrapolations. And sometimes officers just do it on their own without specific scientific training or being able to do that type of analysis, because it's a mathematical equation. Again, it creates a cookie cutter result for an individual that may not be a cookie cutter person. So there's a lot of problems with that, because from the time that they were driving to the time they conduct the field sobriety exercise could be huge. And at that point, having the CAD report is a major thing, because you can create that timeline that sort of Manny and Adam talked about earlier is important in understanding when the Intoxilyzer breath test actually occurs. Remember, there's also a 20-minute observation period that has to be substantially complied with before the first test is actually conducted. And there's a lot of ways of attacking that. Now, you can't attack it for, strict compliance, because the case law unfortunately says, if you're a defense attorney, that, substantial compliance is adequate enough for that observation period because of the administrative rules of how the breath test is supposed to be conducted. Then you have the CMI, which is the company that makes the Intoxilyzer, their trade secret, their source code. None of the officers that are trained on these machines, they don't go underneath the hood. They don't open up the machine. They're not the ones that are maintaining it or trying to test if the lasers are accurate or not. So they don't know it. So it's an avenue of attack for these people that are considered experts on those tests because they don't know how the machine works. And it's sort of going into talking about how the machine has sort of antiquated technology, looking up the reports. If you didn't know this, the Florida Department of Law Enforcement actually maintains records for every single breathalyzer 8000 that is in use. Doesn't matter the jurisdiction, doesn't matter anything like that. If there is a police agency that has an Intoxilyzer 8000, this website that's here listed, the FLD, fdle.state.fl.us, is able to show you results. Now, why is that important? Because there may not be an error that happened on your test at that particular time, but that Intoxilyzer 8000 may have conducted 2-3 other tests that night, and there might have been an error that happened there. Now, if you have no other arguments and you have time to look through the history of that Breathalyzer 8000, you may be able to come up with a defense that goes based on the accuracy of that machine or the number of errors that happens. I can tell you a lot of times in certain jurisdictions, a law enforcement agency may test a Breathalyzer 8000 multiple times that day because it has an error. And it's an error that they don't know, or they don't understand because they don't know how the CMI technology works, because they aren't getting, the privy of the technology or the trade secrets, quote unquote, that CMI has to let them know why that particular error is popping up. All they will do is they will basically do a brute force attack of trying to keep on practicing with the machine until it gives okay, machine valid, conduct test. And you'll see that sometimes that some agencies will have multiple failures of those initial tests, and then all of a sudden the machine works and they use it for the next person that goes through the door. If you ask that breath tech operator why that happened, I can guarantee you a lot of times, 7 times out of 10, they won't be able to explain that answer, and that gives you an attack to proof beyond a reasonable doubt. Now, some interesting case law here is from, again, like you've heard before about how, having Florida law weekly is important. This is one of those traffic cases out of Orange County that talks about how the Intoxilyzer 8000, and it's a very critical critique of it, mostly works. It mostly works. And I can't emphasize that more enough. It mostly works. A 25-year-old piece of technology mostly works. It's insufficient to respond to a citizen's liberty that are at risk. So that constitutional argument that you may forgotten from law school, from doing con law, that the test itself is not a high enough standard to be utilized to take away someone's civil liberties because they got a DUI arrest. Now, we've talked about, and I mentioned the Intoxilyzer 9000. That's the next level of technology. The problem with the Intoxilyzer 9000, I'll just give a brief overview of it, is that it utilizes the same infrared technology that the Intoxilyzer 8000 uses. The only real difference is that the sensors are a little bit more sensitive, so it should have it technically or theoretically should have a more accurate result, but it also includes measuring things like temperature so that they can try to solidify their argument that the machine is valid based on taking other sensor readings like temperature of the breath and other things that different sensors follow. The major upgrade with the 9000 is that it has, USB, the thumb drive technology to store thousands of the results, which the 8000 doesn't have because thumb drives weren't as prevalent back in 2001. But it's realistically sort of this basically the same technology as the 8000. So don't be scared when you see 9000 results. Doesn't mean that the machine is utilizing completely new technology or is better than the 8000. It is just has newer versions for supporting technology to it. Then the next thing that people use and law enforcement uses, as we're going to talk about, is urine and blood samples. Urine realistically isn't a valid test because realistically what it will be measuring is that individual at some point in time had an intoxicant. This is primarily utilized for drug use. There'll be metabolites that shows that someone used cannabis or some other drug, but there's no time frame of how you can determine at what point in time they utilize ethanol or alcohol or cannabis within their urine test. So it's not really the most viable thing in a DUI investigation because it's considering the example of it basically keeping liquid in a Ziploc baggie here, and it's testing it at a different time, and that you can't pinpoint when the intoxicants were used. It doesn't show how much someone ingested. It doesn't show, what level of impairment it created. It just gives people indicators, which can't really be utilized to prove something is beyond a reasonable doubt through that. And in those situations, you really need to ask your jurisdiction for a deposition of the toxicologist that's performing that test, because it is highly scientific, and people can misinterpret what a blood test can show to someone. The blood test you may think is a much more viable standard for someone, and you'll see this a lot of times in more severe cases, not simple DUIs, but DUI manslaughter, vehicular homicides, serious bodily injuries leading to the scene of the accident that's involving impairment, or anything that's involving a felony level of impairment. Now, a lot of times there's two ways that this is collected, and it's either through a hospital where an individual is, or someone consents or they get a search warrant to get a blood sample from them. One of the key things to attack on this situation is the number of preservatives or the type of vials. So you see the vial here in this picture. You may think like, okay, it's a standard vial that should be permissible for the test. No. The key thing to know, and the key note that I'll leave for you on terms of this blood test, is that they have to utilize a standardized blood vial that has a gray top. The reason for that is that gray top vial has the specific amount of preservative in that vial to make sure that the blood does not go bad. And blood will go bad. And when you're in Florida and the heat is a factor, and the officer doesn't have, let's say, an igloo container with ice to keep the blood at a certain temperature, then that blood is going to spoil and it's going to affect the results of the test. So think about that. Think about hiring an expert to help you with this situation, and think about really nitpicking the different questions that you ask for the people that took the blood test. Because also the nurses that they may get the blood sample from, they may not follow that standard either, because they're collecting what's called medical blood, which is different from legal blood. So that's something really important to nitpick on that situation. Furthermore, this is an area where Hunter hearings, which was mentioned earlier on Manning's portion of the test. Hunter hearings are really crucial when it comes to blood tests or trying to get the medical records, because you really want to make sure that the state is held to their burden to prove that they've met the compelling government interest to get that blood sample and violate an individual's medical privacy. That is a huge situation, and a lot of times you can win and stop the blood from coming in because they can't prove that nexus, which is incredibly important. There's a lot of times people, in an investigation, they can't prove that they're intoxicated, so they can't go with a DUI manslaughter. They can't go with a vehicular homicide because the case law says vehicular homicide needs more than speed, and if speed's the only thing they need, they're going to be desperate through their investigation to get blood. A lot of times, these investigations, when you're dealing with these more serious felonies like DUI manslaughter, is an officer is not thinking about that at the moment when the accident happened, the crash happened, the death happened, or the impact happened, because that individual is not dead and they're going to the hospital, may not consider that they need to get a blood sample. So there's a lot of ways of attacking that to make sure that it's not a fishing expedition by law enforcement, and that's where the Hunter hearing becomes very crucial to that. So you really need to make sure that you hold the state to their burden. A lot of times they may not even tell you, they may not give you the notice that is required before they issue a subpoena ducis tecum to get these records, especially on a pretrial thing. But it's important to do that, because if they don't, well, that's an argument for exclusion of that blood sample. That's a discovery violation. That is a violation of the rules of procedure. And it may be a technicality, but it's something that is beholden for the state and the government to prove their burden before they breach that privacy concern. That is a major issue in the state of Florida. So that is it. Like I talked about, it mentioned the nexus between information is important for a Hunter hearing. You request the judge to review it in camera. That is dependent upon your jurisdiction. Here in Broward County, where our office is located, that is the major thing that a lot of judges do. And it's important when it comes to your DUI defense, in sort of harping on the technicalities, the science that is being utilized by the government. Remember, it's not an exact science. Just like a legal opinion can be challenged, the quote-unquote science of the DUI can also be challenged, because there's a lot of problems and uncertainties when it comes to information, and a lot of assumptions that the government has to make too. So we'll open up to any questions, but if not, this is my QR code. If you wanted to ask me any questions about the science of this, I am a nerd and better at math. I would be an engineer. That's what I always tell people, but I love discussing the science and the different types of, trends when it comes to the assumptions that are made for DUIs in the state of Florida based on the Intoxilyzer 8000 and blood testing that's done by law enforcement and by hospitals. Thank you guys all for paying attention to this. And of course, you feel free to reach out to me at any point in time to discuss anything further. Thank you.